Good morning. Today is Friday, July the 9th. We have a busy docket this morning on landlord tenant matters and maybe a civil hearing here and there with a sentencing at 11. And we're going to be off this afternoon. There's a funeral I'll attend. And I'll be gone. I'll be on vacation for the next 2 weeks. Every year in July, I take vacation in the middle of July. And I had a lot of holdover days from last year, unused vacation days. At any rate, we'll be finished probably just about by noon. We started a little early this morning at 8:30. I expect people will be logging in here any minute. We had some extra cases and we put them in at 8:30. We usually start at 9, and we put in 3 more cases between 8:30 and 9. The hope was these early cases would all be settled, and that is still my hope.
Morning, Judge.
Good morning, Mr. Bush. I know you've got a hearing coming up here at 9, so we'll try to get you on your way.
Just have the one matter.
Yeah, but Tina hasn't logged in yet. My hope is this matter is resolved and it will take just a minute.
At the last hearing, they had not been in contact with Keystone. Now, maybe that's changed in the last week.
Yeah, they hadn't heard anything. I continued it 1 week. We did have personal service. No, it's attachment.
That's my notes, yes.
Yes. I guess it's the next one that they thought had been paid. That's probably why Bettina's not here.
Has Keystone run out of money yet, or do they still have funds?
No, they're well funded through the end of the year. In fact, they were sending recommendations on how to utilize additional money by hiring additional staff or setting up some other programming. As you know, last year at the end of the year, we ran out of money and kept doing it anyway. And then we ran out about January 30th. No, money's not an issue. We've got money. There's money to help the landlords, money to help the tenants. We just need to get the
that's our tax dollars at work.
Yes, well, I'm all in favor of tenants not being evicted and landlords being paid.
Yep, it seems to work.
We've got some issues that will probably be arising once the COVID stay ends at the end of the month. There was a lot of controversy about whether the Center for Disease Control even had the authority to do such a thing. And the Supreme Court ultimately said that they did. Then they issued one more stay, and it was a series of about 7 that were either done by the state or by the federal government, which expires at the end of this month, July 31st. So I'm not sure what we're going to find when that stay expires. Of course, you know the law still requires that we have a 30-day adjournment in the non-payment of rent cases, which is like a de facto 30-day extension for everyone. Here's Bettina.
Well, there clearly are jobs available now. I guess that's not quite that simple.
Well, there are certainly, I saw an article this morning, there are people that are looking for jobs and there are employers that need employees and they're having trouble lining the two of them up. Good morning, Bettina.
Good morning.
The first case isn't exactly a Keystone case, at least we hadn't heard anything, but maybe you can enlighten us. I'm going to call the matter of Memory Lane's Mobile Home Park versus Abram Clark and all others. We were here last week, actually about 9 days ago, on this matter. That was alleged to be a rent arrearage through June at that time of $870 or $2,240 plus late fees and costs. At that time, you had not had any contact from the defendant. Has Keystone heard anything from Abram Clark?
No, Your Honor.
Chris Corpening, the manager at Memory Lanes, is here with us now. Ms. Corpening, have you had any contact with Abram Clark? Is he still in the premises?
He is still on the premises. He came in and made a payment, told me he would be in every week, but I've not seen him since.
How much did he pay?
Grab his card. I don't want to make a mistake here. He paid $175.
Chris, can you share when that was, please?
I'm sorry?
Can you share with the court the date that he made that payment?
The date he made it was 6/24.
All right, John, let's recalculate. You've got $2,240. So if we subtract 175 from that.
We may have known that amount, Your Honor. We did the 640 on June 28th. This payment was on June 24th.
Okay, so the payment, yeah, it's on there, absent the June 24th payment of 175. So that was before our last hearing. So you're right, that's already calculated in there. So if we add another $875 for July, I got the sneezes this morning. $3,115. And if we add one more late fee of $20, is it? Or is it 40?
It's 40.
Another late fee of 40. So we have the rent component is $3,115 through July. The late component is $160, and the costs are $176.16. Did you mention, Chris, the availability of potential help from Keystone?
Yes, I did. And he said he had a job and he didn't think he would qualify. I told him I would give him the paperwork and see if he could. He said he would do it online.
And apparently he didn't. Bettina hasn't heard anything from him. And he doesn't show up for the hearings. John and I were talking before he came in the feed. We greatly appreciate the availability of this federal emergency housing money and the staff at Keystone. But we got to get people to avail themselves of it. All right, he isn't here, and he's subject to a writ in 10 days, which is July 19th. As you know, you have 56 days from today to ask for the writ of eviction, so he still could contact Keystone. I mean, the worst they could do is say no. But he could meet me halfway by showing up for the hearing that he obviously knows about. John, I appreciate your indulgence. I told you I'd get you out of here in time for your 9 o'clock hearing. We appear to be in pretty good shape. The only problem will be if this guy shows up late, which is what often happens. I know you're going to be in another court in just a few minutes. Anyway, I made a calculation that through July, he owes $3,115 in rent, $160 in late fees, and $176.16 in costs, for a total of $3,451.16 due by July 19th. It's also the appeal date. Anything else we need to do here?
I think that covers it. Do you have a judgment in front of you, Your Honor?
I do. You'd sent one previously, John.
Thank you, Judge.
So-
Chris, have a nice weekend. Thank you, Judge.
All right, thank you,
Judge.
John.
Thank you.
You have to take an allergy dose here. The next case was Pantoja and Nichols. That's set for 9/40. And that one, the check was in processing. Bettina, what's the status of that one?
The check was mailed out. They have a total of $6,500.
All right. When was it mailed?
It says that the payment should be received for the landlord no later than 7/15. So I'm assuming that he should get it anytime before the 15th.
All right, well, here's Luke Knopfsinger and Shane Nichols. And that 6,500 was to pay the rent through when?
The past rent was a total of $5,000. Future rent for the amount of $1,500. So it should cover her up for the next 2 months, I believe.
All right, well, let's see. Good morning, Mr. Knopfsinger.
Good morning. I'm very encouraged from what I just heard.
Yes, so am I. And Mr. Nichols is here. Just while we're waiting for you to log in, our little guardian angel here, Bettina, tells us that they have mailed out a check for $6,500 to Mr.
Wow.
Nichols. That would be back rent of $5,000 and prospective rent of $1,500, which I think would pay the rent through September. Mr. Nichols, have you received the check?
Not yet.
It indicates it was mailed. It was to be received no later than 7/15. I don't know what kind of snail mail that is, but Keystone has issued the check, which would make you whole for back rent and prospective rent. So I haven't actually called the case. This is file 21653LT. It's entitled Shane Nichols versus Lindsay Pantoja and any others. Mr. Nichols is here. His attorney, Luke Knopfsinger, is here. The defendant is not. Bettina Emery from Keystone Place has indicated, as is stated on the record, they have released a check for $6,500. Luke, what I would propose to do is we do a dismissal without prejudice, and for some reason it doesn't appear, we'll reinstitute the case, but I don't want to make you or your client have to come back again.
Sounds good to me. I guess, as soon as I get word from Mr. Nichols that he received the check, then we'd be good to go.
All right, I'm going to tickle for 10 days. I know that mail is slow and it's about to get even slower, but I expect that Mr. Nichols might get that check as soon as today. at any rate, it's a long way from Centerville to Three Rivers by 8 miles, but it goes here and then back here. And it used to go from the Centerville post office to the Three Rivers post office. Now it goes to Grand Rapids or something. All right, I will note, we will dismiss without prejudice, hold before order sign. Make sure the check clears. Mr. Nichols, is this your first participation in the emergency diversion program?
Yes, sir.
Well, it's a good program, certainly for tenants. It's also a good program for landlords. People are getting more accustomed to doing it. Although we've had defendants, we can't get them in the door. They're probably eligible for some help. We had a guy this morning who didn't show up and didn't apply for help. But hopefully this will help people get on their feet and situated. There's certainly enough jobs out there. Anyway, keep your eye on the mail. Do you have check your post office box today and see if the check's there. And as soon as it is, let Mr. Knopfinger know, and then we'll enter.
Yep, we'll do.
All right. The defendant did not appear, but maybe she just assumes the rent was paid, which it has been. All right, Luke, it seems to me you had to be somewhere at 9 o'clock also today.
Yep.
So thank you for letting us do this early. I got
Thank
you
you.
and John Bush both in and out in time for your next matters. So thank you. I'll see you after I get back from vacation.
Yeah, enjoy your vacation.
you,
Good
sir.
start to the day.
Mr. Nichols, good luck.
Bye.
Bye.
All right, Mr. Larkins is here. Our next matter is 950. Good morning.
Morning, Your Honor.
I'm going to put you in the waiting room. Miss Bratcher's not here yet, but we're right on time. We haven't backed up yet. We will be shortly, but right now we're in pretty good shape. So I'll put you in the waiting room and bring you back in just a moment.
Okay.
Bettina, this is Larkins versus Bratcher. It was filed as a termination of tenancy. There's a rent arrearage. The defendant didn't show up for the initial hearing. Then she basically said she just forgot. And then she made a motion to set the judgment aside. And I advised her of her rights and extended it for 10 days without ruling on the motion. She said she was going to retain counsel or get legal aid, and at this point I haven't seen anything from anyone. So there is a rent arrearage. The landlord doesn't want rent, he just wants her to move.
Mm-hmm.
We have a lot of first hearings today, which will entail just advising of their rights.
Yes.
And
And
then
then-
at the end, we have the Kloppenstein case,
Mhm.
and Keystone did make a substantial payment.
Yes.
Plaintiff was still asking for a hearing because supposedly there was a month that was unpaid. I don't know what the status is. I guess we'll find out when we get everybody here. But that was a difficult case and a lot of arrearage. So, all right, I think we've got Ms. Bratcher here. All right, good morning. We are on the record and we are on Zoom and we're on the YouTube live stream. This is Scott and Annette Larkins versus Sydney Bratcher. Good morning, Ms. Bratcher. Can you hear me?
Yeah, sorry. Yes, sir, I can.
Okay. Let me give you a name. Okay, this is file 21843LT. I set it for this morning before we started our full docket. This matter was somewhat contentious. It's filed as a termination of tenancy action. It was set for June 18th. Now, the defendant did not appear, and there was personal service. So she had personal notice of the hearing. In a termination of tenancy, when there is personal service, the plaintiff is entitled to a default judgment if the defendant does not appear. So I entered a default judgment on June 18th, giving the defendant until June 28th to move or be subject to a writ. The defendant then, I'm not sure what happened, but she got the judgment and then she asked to set it aside, essentially saying, I was working and I got mixed up on my day and I thought the court day was another day and I didn't show up. So I set the hearing on the motion to set aside the default. I haven't made a ruling on that yet. That was on July 2nd. I did advise the defendant of her rights as a tenant in a landlord tenant proceeding at that July 2nd hearing and continued the matter for 7 days until today. Mr. Larkins indicated he still wishes the defendant to vacate. She raised some issues, said she was going to contact legal aid or retain counsel. So the matter was set for further hearing today. Mr. Larkins, is your position the same? You wish the defendant to vacate so you can make improvements to the unit?
Yes, Your Honor.
Ms. Bratcher, what's your position?
I mean, that I feel a little unfair about it just because I asked for the mold to be fixed and I got told that it was going to be fixed and it never got fixed. And I mean, that was the issue from the gate. Like I said, I've been trying to move anyways. I just haven't been able to find a place. I am a single mother with 2 children. And I mean, I'm at work right now. And I mean, I still feel like it's a little unfair. I asked Kate multiple times to fix something and she just. Did
you ever contact legal aid or other?
I called Keystone a couple of times. I had to leave a message. No one has called me back. I've called them 2 or 3 times this week. And then with legal aid, I was on hold for like 45 minutes and no one ends up answering. I mean, I work 12-hour days, 10 to 12-hour days. So by the time I get off work and I'm on hold for 45 minutes, it ends up just hanging up on me.
All right. I forgot where you worked. You told me last time.
R&R trailer.
Okay. All right. Well, I never made a ruling on the motion to set aside the default. I advised you of your right to counsel. I gave an additional 7-day adjournment, and your original reason for not appearing for the hearing, I just forgot, isn't sufficient.
No, Your Honor, it wasn't I forgot. It was I had my court dates mixed up.
All right. Well, that's true. You had a hearing allegedly in Oregon, but at any rate, you didn't show up. They were here. You have some sort of unpled retaliatory eviction. But the bottom line is you want to get out of there and he wants you out. The underlying problem is there's nowhere to move to.
Right. And I'm trying and I've been looking and I mean, and now I'm hearing that I'm being like accused of continuously having someone live in my house. Your Honor, I'm a single mother, have been. And it's just, it's ridiculous whenever I'm hearing someone's asking around town about me and they can't even ask me themselves.
Well, I don't know anything about that, and that isn't certainly any part of this. I never met you before this. I told you I know this apartment. I lived 100 yards from where this building is when I was a kid. But I'm gonna find that he's entitled to the relief that he's asking for.
And that's totally fine. I mean, I don't mind giving the apartment back.
Listen to what I have to say here, because this is important. I'm telling you, you have until July 19th, which is 10 days from today, to move or you're subject to being evicted. When you move, you need to turn in the keys and give your forwarding address within 4 days of your moving. Now, Mr. Larkins knows this, but you don't. The 19th of July is a Monday. That's the very first day he could do an eviction. He doesn't have to do the eviction for 56 days from today's date. He has discretion. So for example, if the eviction date is March 19th and you say, I've got a place to move to, July 19th, I have a place to move to on July 21st, he doesn't have to pursue it. He can simply wait for you to move out. Eviction's a messy process. The sheriff comes with a crew and they put all your stuff out on the street.
Yep.
So he has discretion to work with you, but he does not have to. He started this, the notice to quit was a long time ago. And Ms. Bratcher, in a different time and place, people would just move. But
And
right
I've been
now,
trying. You don't think I've been trying?
well, I believe you. I hear this story every week, every Monday and every Friday. People are dissatisfied with their landlord. They don't like their unit. They want to move. They can't move because they can't find a place to go to. So I don't disbelieve anything you're telling me. You're a young woman that's working hard, trying to support your kids, make your way in the world. The other side of the equation is this landlord wants to terminate this tenancy. I don't get to make up the rules. I just have to follow them. All right, I repeat that. He doesn't have to evict you for 56 days. By the letter of the law, he can evict you on or after July 19th. I'm not ordering any money damages. I'm not ordering that you pay anything at this point. When you send in your keys and forwarding address, it triggers the security deposit law, and he can make a decision whether to return the security deposit or apply it to unpaid rent. Let me also tell you, you do have 10 days to appeal this if you contact legal aid or other counsel. You were adamant last week that you were going to get a lawyer, but...
Yeah, and I tried.
All right. All right. Anyway, that's it. You have 10 days to appeal it or 10 days to move. And I'll send you this in the mail. All right. Thank you. Mr. Larkins will send that out.
You know, Judge, we have like millions of dollars for, you know, landlords and tenants. It would be great if we had some of that money to build up more affordable housing so people could have somewhere to go.
It certainly would. Our toughest cases are these termination of tenancy cases. The non-payment of rent cases, we can find a solution. But I've got a couple of cases where the landlord wants to sell the house. They have a standing buyer ready to buy it, and they can't get the tenant out. And that's certainly, that's the case with the case we have later this morning. The guy's got a buyer ready and willing to buy the property. Good morning. This is Judge Middleton. We are here in open court. I've got a phone number here. Is that Lacey Harker?
Yes, sir.
All right. Robin Standish is here representing herself. We have, starting at 9, I might as well just get at it. I've got to advise the advice of rights. If the other person was here earlier, I could do this. Well, let's talk about this. Ms. Standish, your stuff's a little confusing. Some of it is half termination of tenancy and half non-payment of rent. I've got with us Bettina Emery from Keystone, who's our local housing advocate, who has to do with helping landlords and tenants get their rent paid. This first case, Robin Standish versus Lacey Harker, 21964 LT, appears to be filed as a termination of tenancy case. There is a lease which went from 3/6 of 20, and then it was month to month, and I think a 1-year lease, then month to month after that. The lease ended, no, it was a 6-month lease, August 30th of 20, and then it's month to month thereafter.
That is correct.
I'm familiar with this building. I've had dozens of cases in this building over my career. Some criminal cases, a bunch of landlord tenant cases. You're about the 4th or 5th landlord in line here. Frankly, I'm surprised the place even meets code requirements unless you've done a lot of improvement to it. But this involves a property at 230 Portage Avenue. Ms. Harker, your landlord wants you to move, and you have certain rights as a tenant in a landlord tenant proceeding. And let me tell you those now. Can you hear me?
Yes, sir.
As a defendant in a landlord tenant proceeding, including termination of tenancy, which is what this is, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, which this isn't, Keystone could be available to help, or other federal. You would not need a judgment. The summons and complaint are sufficient. We have that now. If the plaintiff is agreeable, the Citizen Mediation Services, Inc. may be a possible source of case resolution. If both parties are agreeable to mediation, the court can set that up. That's actually yet to happen even one time. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 business days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment will stand. Ms. Harker filed a bunch of stuff with the court, photographs, emails, that sort of thing. Ms. Standish, did you get copies of those things?
No, Your Honor, I did not.
All right, we're going to have to get through that. This apartment is screwy. Stuff's on the same meter, the gas bill, electric bill. I've had a lot of issues with this building over the years, and Ms. Harker raises a number of those issues in her responses. Defendant forwarded documents to the court, but not to the plaintiff. The court, see to it our staff forwards all those documents to you.
That would be great.
How long have you owned this building?
We have received it back in 2015. Wait a minute. No, 2019. We received it back on a foreclosure via Patricia Barnhart, and Ms. Shancy helped us get it back.
Well, I remember that, and there was a mess. She had all kinds of issues with it, and it looks to me from the photographs, there's still all kinds of electrical issues and other stuff. Has this passed city inspection?
It has, Your Honor, and we have actually had the electrician came through and did an inspection on it, and it was state certified as a daycare at one point. But the meter and the gas is on one meter. It is under a grandfather clause, and it is divided by the occupants. And we informed Miss Harker when she first rented, but we didn't have any issues because we didn't have anybody in there. The person that during COVID had a stroke, so it wasn't available to rent. And when it was rented, the other side was rented, immediately I had started, I let Miss Harker know and told her to, forward me any, the information for the bill.
Let me stop right now because we're not going to get to all these issues at this point. Law requires that I set a second hearing.
Okay.
We used to just get to it. I've advised Ms. Harker of her rights as a tenant. I'm going to forward you everything that she sent to us. These pictures I'm seeing seem to show all kinds of code violations. So I'm not sure. There's always two sides to every story. Now, Ms. Harker in her stuff talks about how deplorable the place is. And I tell people, then move, except they don't have a place to move to.
I think she's vacated.
Ms. Harker, are you trying to find another place to move to?
Actually, Your Honor, me, my mother, and my 2 children have moved out of that home.
Okay.
We have officially moved out, and the keys are on the counter. Our last day there was last Thursday, but I finished moving everything out on Sunday afternoon.
All right. So do you have any objection to an order granting immediate possession to the Standishes?
They can have it.
All right. Very good. I'm going to show a consent order for immediate possession. And it has vacated.
I will also be emailing you a new address for any court paperwork, sir.
All right, I'm still going to send that paperwork to Ms. Standish. There's no issue regarding money damages here. Now, we just entered a consent judgment, and I don't think anyone's going to change their mind. I'm going to repeat what I told you. It might make more sense now. The consent judgment may not be enforced until 3 business days have passed. You may have moved to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside judgment would be set for a hearing. So in this case, you've already vacated and moved, so it's very unlikely that this will happen, but I will find that the plaintiff has a right to recover possession. There is no money issue. You will forward us your forwarding address. Keys are on the counter. And Ms. Standish, I'll still send you all these pictures and you can see I never had to actually get into the meat of it, which I'm pleased about, but I guess you're certainly entitled to see all that. All right, I've granted that the plaintiff may have immediate possession. The defendant has vacated. Keys are on the counter, and the defendant will be sending us her forwarding address by email. She's been in email contact with the court. Is there anything else?
Your Honor.
Yes?
Yes. So the door was changed out, and there was a new doorknob. Is the locks the same?
The keys are all there. If I have to, I can drive down because I know my mom still has a set I have to drop off. I will unlock the back door and I will put them on the counter for her. And I will leave the door unlocked for her.
No, you can't leave the house unlocked, but is the keys the same ones that we issued to you when you rented?
No, because that whole deadbolt was broken, but I told the judge I replaced that, and I replaced the toilet seats that my children broke. I replaced the
All right,
faucet that my children broke.
All right, well then let's talk about this. You can either just break in, which isn't ideal, or you can agree to meet at a time and give you the new key. What time can you be there, Miss Harker?
I don't get out of work till 3:30, and I work in Kalamazoo and live in Kalamazoo now.
All right, at 4:30 today, you meet at the premises and exchange keys. Will that work?
Yes, sir.
It works for me as well.
All right, that matter is concluded. Ms. Harker, you're free to go. I'm glad you found alternate housing. Our next matter is set for 9:10. It's 9:06, and Christian Ashford has just checked in. Mr. Ashford, can you hear me? You need to unmute your microphone. Good morning. This is Judge Middleton. Am I speaking with Christian Ashford?
Yes, you are.
Is Jasmine Armstrong with you?
Yes, it is.
All right, very good. Thank you both for being here. Do you have the ability to do video?
Yes, I do. Just give me one moment, sir.
All right. Ms. Standish, this
Yes.
is a situation where I wish you had Miss Yancey helping you. She's one of the best she and Jordan both are some of the best landlord tenant attorneys we have here in the county. And they help
Yes, she
you
is.
in a very difficult case, but this case is sort of half one thing, half something else. We'll see if we can figure it out.
And it was, that's
Well,
my
I
fault for
don't
not getting here.
I don't want to say too much because they're still on mute.
Oh.
Mr. Ashford, could you unmute your mic?
Yes, I am here, sir.
All right. There we go. Good morning to both of you.
Good morning.
Good. All right, this is Judge Middleton. I'm here at the courthouse. We've got your landlord, Robin Standish, and there's also a lady here on the feed named Bettina Emery, who is from Keystone Place. She's our local housing advocate, or one of them. This is a case that has, I can't quite figure out what flavor it is. You got a notice to quit and a demand for non-payment of rent served up you on May 2nd.
I got a picture of it on my phone.
Well, I have it right here. It says you owe $500. So you were served notice as a demand for non-payment of rent. Then they filed some stuff indicating that it's kind of screwy. I can't quite figure it out, but it alleges that there's unpaid rent and fees. But it isn't broken down right. Then they filed a complaint to terminate your tenancy. So they gave you a notice to quit for non-payment of rent, and then filed a complaint for termination of tenancy. You're not really supposed to do it that way. And so this is, sometimes you get into problems when you have people representing themselves. And if it is a termination of tenancy, it's for non-payment of rent, and will not respond to landowners by phone or text. If it is a non-payment of rent case, Keystone to help pay the rent. But very first of all, before we start, let me advise you of your rights as a tenant in a landlord-tenant proceeding. Oh, I apologize. I've got bad allergies this morning.
No, you are perfectly fine, sir.
This is, well, it won't be when I start sneezing here in a minute, but we'll hope for the best. As a defendant in a landlord-tenant proceeding, including non-payment of rent, termination of tenancy, or other, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services, in our case, that's Keystone, or other agency may be able to help you with payment of some or all of the rent. Defendants do not need a judgment to receive assistance. The summons and complaint from the court are sufficient. If the plaintiff is agreeable, the Citizen Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable to mediation, the court can facilitate that. If you reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. As I indicated, this was filed as one thing and then filed as something else. What is it, Ms. Standish? Is it a termination of tenancy or is it a demand for payment of rent?
I apologize, Your Honor. It is a termination for non-payment of rent. I had filed this electronically with her. I filed her taxes and she's been, was communicating with me, and then all of a sudden they just quit communicating. So I have no idea what's going on.
Well, there is no such thing as termination for non-payment of rent. It's sort of half one, half of the other. It's demand for possession for non-payment of rent. How much is the arrearage? I got your breakdown sheet here, but I couldn't quite figure it out. Through July, how much is rent?
Rent is $200 per week, and that includes the electric and the gas and the water.
All right, so how much is
her last payment was paid on April 19th, so she wasn't paid. Rent was not due until the 23rd of April, which was $200, and then every 7 days after that.
Well, how much is the? I'm going to ask you this every time.
$2,400.
Through when?
From April 23rd till today.
Is $2,400 in rent. All right, what else is there?
There is $90 in late fees. And that is for April, May, and June.
All right. And you've got a water bill of $188.
That would not be normal that they'd have to pay that, but because of the non-payment of rent, there was no monies coming in on either side. So I have been carrying all of it, including the mortgage, I'm actually in forbearance on my own property because it's on my property because no one has paid rent since May, and she has not paid rent since April.
All right, well, yeah, I talked about the difficulties with this building. All right, so that's how much is due. Keystone could be available to help them pay their rent. In a non-payment of rent case, Keystone could pay their back rent and some prospective rent. You have to agree to participate in the program, and the defendants fill out the application. Are you available to do that?
I have been open for communication. Jasmine is actually a relative, and I have been open for communication. I don't know what happened. They haven't spoke to me or answered the phone, so I don't know what's going on.
Have you done this program before through Keystone?
I have for Lacey.
All right, so
the
you're
prior
familiar.
tenant.
All right, the law requires that I adjourn this for a second hearing. In a non-payment of rent case, it's 30 days, and a termination of tenancy case, it's 7. You're interested in getting the rent paid. You gave them a notice to quit for non-payment of rent. So both sides need to get in contact with Keystone, and I'm going to adjourn this for 30 days to August 9th. Let's see what I got. Let me repeat.
Now, Your Honor, I do
Yes.
have one question. So Jasmine had approached me in February, and they were not employed, but they were receiving assistance through the unemployment. And so the lease was only till August 26th. I don't know now that I do know that Christian has obtained employment, but I believe it's in Battle Creek. I'm not sure if this is what they want. So I would like you to find out if that's what they want.
What do you want?
Me?
No, Mr. Ashford and Jasmine, what do you want?
Well, my employment is actually in Portage. It's not in Battle Creek. So, where exactly is the Keystone location at, if I may ask?
It's in Centerville. I think we already sent you that information. But let me ask, do you wish to stay there or do you wish to move?
Well, we want to move. We just wanted to get this handled first. And as far as the communication, there was communication almost every 2 weeks because besides them calling and texting me, her husband was actually watching my Facebook.
Well, that's not much communication, but all right. You have the right to apply for emergency eviction diversion funds, which gets your rent paid and gets your landlord paid. She filed this as a non-payment of rent termination, and then turned it into something else. I'm going to treat it as a non-payment of rent case. Your obligation would be to contact Keystone. I'm going to continue this until August 9th.
We agree.
So once we...
All right, now let me give you this number right now. Do you have something to write on? Nobody ever does.
Yes, we have something to write on.
All right, but Tina, why don't you give them your number?
269-467-7078. Extension 1. Huh?
You said your name's Tina?
Yes. Extension 120.
All right, now lots of federal money has been allocated to help people pay their rent. It helps the landlord. There's a bunch of problems with this building, and not the least of which is different apartments are sharing water and gas and electric meters, and I've had to try to unscramble this multiple times. Most of the people there want to move somewhere else, but they can't find somewhere else to move to. In the meantime, the landlord's got these apartments that no one's paying any rent on, and then she can't pay her note, and it's bad all the way around. So you need to either move out, or you need to contact Keystone Place and see about getting some emergency financial rental assistance, which could pay your back rent and some of your forward rent. I don't know what your employment situation is and how that will affect it, but I won't know it if you don't apply. Then our next hearing will be August 9th at 2 o'clock. That's 30 days, actually 31 days from today. If no rent is paid at that time, I'm going to give you 10 days to move out or be subject to being evicted. So we will address this matter on August 9th at 2 o'clock and see where we are. Ms. Standish, you may want to contact Keystone also to make sure all of your information is current and correct.
Okay.
We had a guy this morning, he got $6,500, several months of back rent, 2 months of prospective rent. He was quite satisfied with that. So let's hope we can accomplish something like that here, or they'll move out and then we'll worry about money later. All right. In the meantime, this matter is adjourned until August 9th.
Thank you.
All right. Thank you so much.
Oh, I do an allergy spray and I forgot to do it this morning. All right. Next, I've got Mr. Reagan's in the waiting room. This matter is set for 9:20. We're 2 minutes behind. Good morning, Mr. Reagans. Can you hear me?
Yes, sir. Can you hear me?
Yes, I can.
Morning, sir.
Good morning. This is file 21959LT, Tony Reagans versus Whitney Haroon and all other occupants. Mr. Reagans filed this action on his own as a termination of tenancy. This is for a property at 1206 3rd Street. Mr. Reagans, do you own the property at 1206 3rd Street?
Yes, sir, I do.
All right, but you've been living on River Road. I've known you for a number of years, and I've known you as River Road. I didn't know you owned this other house. How'd you come to own that one?
My grandmother.
Okay.
Viola Gray.
What was her name?
Viola Gray. Viola
Oh,
and Harold Gray.
Okay, I knew them. They both passed?
Yes, sir. My grandmother passed away in 2014.
Whitney Haroon is not here.
Yes, sir.
Does she know about this?
She was processed and served about it.
Well, it says here you served her yourself, which is always a little risky, but did you drive over there and give her this?
Not actually, yes, that was one of them. And then I got a letter in the mail stating that the process server for the court processed her also.
Yeah, I see a service by Sergeant Moore. Tells me somebody was served. They were served.
Yes, sir.
So she does know. We have
I actually talked to her last night, but she didn't mention nothing about court, and I didn't say nothing extra. So,
all right. There's no lease here, is there?
no, sir, no lease. I made the agreement between me and Mr. Robert Curtis, is the main person who's renting the house from me, and between them two, the domestic stuff going on there, and there's a lot of confusion. So I'm trying to eliminate the source of the confusion. Is he says the girlfriend is the source of the confusion.
So you're only evicting her?
Yes, sir, just to get rid of the confusion, because the police was coming there, and she was be gone when they come there and run away when they come, and she'll talk to them from what I understand, and it's just a lot of confusion. I just don't need all that extra confusion. I just want the trying to sell the place. So Robert is getting the place ready to sell, and I had trees cut down, and just a lot of confusion.
Well, the law says I have to adjourn it 7 days. The problem is, Mr. Reagans, I'm going to be gone for a little bit. So let's find the next date.
Yeah, I'm actually in Mississippi myself.
All right. How's the weather in Mississippi?
It's hot, 95. Just getting the business. My great aunt, my auntie passed, who was a police officer here in town last month, and she been taking care of my property down in Mississippi. So I had to reconfigure with lawyers and stuff this week and next week. So just trying to get all my property and stuff in order, my business straight down south here. And I just got back on my feet. I've been down with this prosthetic. I just got my prosthetic April 20th.
Yeah, you've had some health issues, so that's good to hear. You were in Mississippi last time I talked to you also.
Yes, sir.
I'm going to continue this. I apologize because of my vacation.
It's understood.
I have to go at least 7 days anyway, but I'm going to go to July 30th at 9:15.
All right.
Defendant failed to appear. If she moves, you can simply dismiss it. If she doesn't move, I suggest we have a second hearing and make a record. At that time, I would entertain a motion for a writ to terminate the tenancy with an eviction date. So she's not here. I've continued this to July 30th at 9:15.
Yes, sir.
All right, you take care down there in Mississippi and get used to your new land. You got all kinds of property to deal with, but all right, I'll see you on the 30th of July. It'll be by Zoom once again. At some point, we may be doing these live again, but for the foreseeable future, it'll be by Zoom. All
Yes,
right,
sir.
you're good to
Well,
go.
you have a good vacation, sir.
All right, thank you.
All right. Talk to you later.
Okay, our 9:30 case is Rama and Buchanan. And the next couple are termination of tenancy cases. I'm sorry, Bettina,
That's understandable.
doesn't make for very good TV. The judge blowing his nose here all the time, but we'll get through this. We're in pretty good shape. We're about right on time. We have a 9:30, 9:40, 9:45, 9:50. Then we have some civil motions, and then we have an 11. So, and then I have a sentencing I crammed in here also later in the morning.
Do you need me for the 11 o'clock landlord tenant case?
let me tell you, I'm gonna need you on Kloppenstein and Schroeder.
Yes.
The 11 o'clock one is, I don't remember what this is. Oh, no, this is the house that's unlivable. It burned. And they're not eligible for any housing assistance because the property's not livable. And so, no, I won't need you for that one.
Okay.
All right, so I got, excuse me. Oh, pre-termination of tenancies. I'm gonna go get some allergy spray and hope for the best.
Okay.
I have some in my truck. Good morning. We'll be with you in just a moment. Thank you for waiting. I had to go out on a sneeze break. Now, here's Miss Haroon.
Morning.
Good morning, Mr. Brothers. Miss Haroon, can you hear me?
Yes, I can.
Your hearing was set for 9:30. Wait a minute, 9:20. Mr. Reagan's was here. He says you're still in the premises. I have continued the matter until July 30th. Can you hear me?
For George Weisel?
No, Miss Haroon, you're here on Tony Reagan's, correct?
No.
No, Miss Moreno, I'm not speaking to you. I'm speaking to someone named Whitney Haroon. You're here as the manager for Tradewinds. This is a defendant who was late. Now she's clicked off. So the esteemed Robert Brothers has joined us, and I've got another attorney waiting. Miss Haroon, can you hear me? This is a continual struggle connecting with people by Zoom. Miss Haroon, can you hear me?
I can hear you. Can you hear me?
Yes. You're late to the party, but let me advise you of your rights as a tenant. Your hearing was set for 9:20. We had the hearing and you weren't there.
I was trying to get on and it wouldn't let me connect.
All right. Well, the time to do it the first time isn't 1 minute before the hearing starts, but you're here now, so let me advise you of your rights. As a defendant in a landlord tenant proceeding, including a termination of tenancy, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have a right to a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services, which is Keystone, could help you with some or all of the rent, although this is not a non-payment of rent case. If the plaintiff is agreeable, the Citizen Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable, the court can facilitate that. If you reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. So that's what I would have told you if you were here. So I advise you of your rights.
Yes, sir.
Mr. Reagan's indicated that he wants you to move out. He's evicting you only, not Robert Curtis. He also indicated that he wants to sell the house.
Yes.
I've adjourned this to July 30th at 9:15. You're going to get a new notice. So you're late, but I did advise you of your rights and advise you that the matter's been adjourned for a second hearing for July 30th. You have a right to seek a legal counsel, or you also have the right to move. And at any rate, there will be another hearing. It will be by Zoom, and you need to show up on time. We've got these hearings set on very short turnaround time, and this just backed us all up. So
I downloaded that app. It said that I was connected and then it wouldn't go to the video things. So I was trying to call the courts and they couldn't hear me. So I had to go through the whole app thing again. And that's why I was late. I was actually, ready for you at 9:05.
Okay. Well, I told you everything I would have told you if you'd been here. So July 30th at 9:15 is our next hearing. Okay?
Okay. At 9:15, because
Yes.
no. Okay, 9:15.
You'll get that in the mail. All right, thank you.
Thank you.
All right. Well, we're a little late, but not bad. Our 9:30 case, Rama versus Buchanan. No one has appeared for either side. Maybe they've moved. That brings us to our next set of cases. We have Mr. Brothers, we have Angie Mingus in the waiting room. We have Navyat Francis, attorney, in the waiting room for trade winds. Oh, wait a minute, they're on a civil motion. Good morning. Miss Mingus, can you hear me?
Angie, you're on mute.
I'll send a little unmute. Bob, you don't come a lot, but this is a daily struggle. Miss Mingus, can you hear me?
I can now.
All right, thank you.
Do you prefer I have video or no video?
I prefer video if you have it.
I do.
All right, very good. It is 9:43. This matter was set for 9:40. I'll call it. It's entitled Virginia Mingus and Angela Mingus. Wait a minute, let me make sure I got it right. Virginia Mingus and Angela Mingus as trustee versus Marcia Gonser. This is a property out on Thunderbird Drive. Mr. Robert Brothers is here on behalf of the plaintiff. This is a termination of tenancy action. Notice to quit was served on May 6th. I wasn't clear if there was ever a lease. Was there a lease, Mr. Brothers?
No, Your Honor. The defendant took possession of the property purportedly as the trustee of the Virginia Mingus Trust. And I believe that was approximately 3 years ago. And because of her behavior, the probate court removed her as trustee. So one of the bad behaviors is using trust assets, and the house is a trust asset. So Angela Mingus was appointed as trustee by the probate court. I've indicated the probate court file number in the filings, and so that she had no right to live there in the first place, and she continues to have no right. So Angie Mingus, as trustee of the trust, is pursuing this action to remove her as a tenant at sufferance.
All right, the law requires that I set this for a second hearing at least 7 days away in a termination. Let me see what we got here. In a termination of tenancy case with personal service, I have the right to do a default. This service is by attachment. As far as you know, is she still there?
As far as we know, do you know anything further, Angie?
I don't know anything further. I have not been by there for a week or so. But at last, she was still there.
Your Honor,
Now-
I'm sorry, the return of service indicates that Mr. Morris went there 4 times. Several times there was a car in the driveway, but the door was not answered. So that is the extent of what we know of whether she's still in possession.
Sergeant Morse does a excellent job, as you know, of serving all our process, and it appears she is still there. Who was Virginia Mingus to Marcia?
Her mother.
Okay. Well, the law requires I set a second hearing, whether we like it or not. And the problem, Bob, is I'm on vacation till Halloween.
Till Halloween.
I felt like being on vacation till Halloween. Maybe that's it. No, I'm on vacation for the next. So my next available date is the 26th of July. And so I'm going to have to continue this for a second hearing. If we had personal service, I could do a default. So let's set this for July 26th at 1:30.
Very good.
Tenant failed to appear. No personal service. As you know, these family situations can also be very difficult. There's probably also an issue of dissipation of the property and other issues. But we'll set the second hearing at our next available date. And that's the best we can do here this morning. Anything else we should put on the record here?
I don't think so, Your Honor, other than I hope you enjoy your well-deserved vacation.
Okay. It's one of those vacations where I do this every summer. I take a vacation and then I stay home. It's part of the plan. All right. Thank you.
Thank you.
Ms. Mingus,
Thank you.
I'll see you on the 26th. All right, now let's bring in Lance Thornton and legal aid. Ms. Francis, which case are you here on? Are you here to assist in trade winds?
Good morning, Judge. I am here on behalf of Bradshaw's office on Tradewind.
Okay, I hadn't seen you here on their behalf before. They must be on vacation. We had Mr. Becker last time, and now you're here. Let's call that case. We've got the parties here on our next matter. Let me set this aside. All right, Ms. Moreno, now we're on to your case. Let's see who this person is by telephone here. I gotta look to spell your name right. And thank you for putting your P number in there. That's very helpful. 7232322. All right, we'll call this case. Who's on the phone here? I just brought in 269 279. Is that you, Mr. Kloppenstein?
Speaking, yes.
All right, let me give you a name. We'll get to your case here in a minute. We got another one we got to do first. I've been having allergy problems this morning. I went out to get some allergy spray and found an empty bottle in my truck, so that wasn't very helpful. So my apologies in advance. All right, our next matter is entitled Trade Winds, I think it's Wiesel versus George Wiesel. We learned last time on July 2nd, Thomas Becker was here for the plaintiff and their manager, Amber Moreno from Trade Winds was here. We learned that Mr. George Wiesel is in a nursing home, medical care facility, and he's not living in the premises. No one else is living there, but he had not vacated. The relatives had moved out some of the property, but not all of it. Because it was a termination of tenancy hearing with attachment service, I set it for another hearing 7 days later. Now we have Francis, who's here on behalf of the plaintiff. We have Ms. Moreno once again. Ms. Moreno, would you unmute your mic? Has anyone moved his property out?
No, nobody has been there.
Well, at this point, you're entitled to a possession judgment with 10 days. I don't have one in the file. I don't think. Usually Bradshaw's pretty good about it, but I don't. Plaintiff is entitled to have possession of the property within 10 days. Ms. Francis, you can either submit or have their office submit a judgment for the possession date of July 19th. It's also the writ date.
Yes, Judge. Can that be faxed or emailed over?
Certainly. They do that all the time.
Okay, I will have them.
I forgot are you in Kalamazoo?
I am in Detroit, Your Honor.
That's what I thought. I didn't know how, that's why I was surprised to see you here on this case. At any rate, either you or them can submit it. And Ms. Moreno, I'm sure you're not just going to throw his stuff out in the street, but what you're looking for is a family member or someone to come get his property. It doesn't appear he's ever going to be coming back.
Right.
So I'm sure you'll be working on that. All right, anything else we should place on the record?
No, Your Honor.
All right, thank you.
Thank you, Judge, and enjoy your vacation.
Oh, thank you.
Thank you.
Okay, thanks. All right. This is a hearing the court kind of set to see what the status of this is. Let me get it. Bettina, if you could rejoin us, this would be helpful. Thank you. This is file 20350LT. It's entitled Ronald and Carol Schroeder versus Craig Kloppenstein. It's the oldest case I have, oldest landlord tenant case I have. It goes back more than a year. We had a hearing in May. Well, to further back things up, the original counsel was Deborah Davis for the plaintiff, and Deborah Davis left private practice and went to work at the prosecuting attorney's office. So the Schroeders and I'm pleased that they did, got new counsel, and they have Mr. Lance Thornton, who's an experienced landlord tenant attorney. I got notice, well then, Rebecca Johnson from Legal Aid got involved representing the defendant. She's here this morning. Also, Mr. Lance Thornton is here with the plaintiffs, and Mr. Kloppenstein is here by phone. The Legal Aid has filed a motion to quash order of eviction and enter satisfaction of judgment. I was very pleased to hear that there was some sort of a conciliation from the parties, and Keystone paid a substantial portion of rent. In fact, I thought all of it. And there was a settlement statement, and then the motion to quash. Bettina Emery is here on behalf of Keystone Place. Miss Emery, can you tell us how much was paid?
Mr. Kloppenstein for Mr. Schroeder was paid in past rent for the amount of $7,425.
And that's certainly a big deal for the Schroeders. That's a lot of back rent. So when was that paid?
I believe that was paid
Your Honor, payment should have been received early June. I don't have an exact date when the check was issued to the Schroeders.
All right. It was envisioned to pay the rent through what date?
It should have covered rent till the end of August of 2021. So there is still a balance remaining. This motion is in regard to the writ that was entered on September 4th of 2020, which due to the Supreme Court order in the 56-day rule, since the 56-day rule has been suspended, I would like to have that writ quashed because it's been satisfied through the payment of the judgment.
Your Honor, I have my supervisor, Sandy Cook, here that can give a more detailed explanation of Mr. Kloppenstein's case.
Hello, Sandra. Nice to see you this morning.
Nice seeing you. Okay, we paid the $7,000 because we were told that at the end of June, he would have to leave the premises. So we went ahead and paid till June and then put his $1,150 future rent into escrow. And I let him know that when he left that resident and he found another place, then we would be able to help him with first month's rent and deposit and probably 3 more months of rental assistance. And I hand delivered the check to his landlord.
Your Honor, could I interject here?
Just a minute. I will let you, certainly. All right, so Keystone's understanding was they were paying the rent through June. In previous records, Ms. Johnson, you weren't yet in the case. The indication was that the Schroeders wished to sell this house. They have a buyer and they really would like to get the tenant out so they can sell it. Mr. Kloppenstein has been there. He's indicated he's been actively seeking other housing. Hasn't been able to find it. The stays have been in effect. So the stay was through June 30th. It got extended through July 31st. But frankly, at the end of July, I think the stays are over. I'm very pleased that the Schroeders got $7,400 and that they're made whole for all the time that Mr. Kloppenstein has been there. Mr. Kloppenstein is a difficult tenant to locate because he has a number of cats that are important to him, and landlords don't want to often rent to someone with 12 cats. But so we're stuck between the proverbial rock and the hard place. All right, Mr. Thornton, now what did you want to tell us?
Well, the most important point is it's our contention that the Keystone payment of $74.25 did not include June's rent. That payment only goes through the end of May of 2021. And I confirmed that through email correspondence with Ms. Cook as part of a few weeks ago, that payment to the Schroeders did not include June's rent. And Mr. Kloppenstein has not paid June's rent.
And now we're in July.
And that is the case. I do not dispute those facts, Your Honor. My motion is in regard to the eviction that was issued back in September of 2020. And due to the suspension of the 56-day rule, I would like that the writ to be quashed so it cannot be used to terminate the tenancy based on this case moving forward, because the judgment that was issued has in fact been satisfied as proved by the settlement statement given to the court.
Ms. Cook, can we use the escrow funds that are being held aside to pay June and July's rent?
Yep, I'll look over that because it looks like we did pay June by the ledger that we received.
Sandy, I can't hear you when you turn away from the mic.
I'm sorry, I was looking at the notes here. It looks like by his ledger that he sent, the landlord sent us, it looks like we paid till June. I can look at that and see where we're at. But if we need to pay June and July, we'll just take that out of escrow and go ahead and pay that amount.
All right, that would make the Schroeders whole through July.
Yep.
It would get Mr. Kloppenstein paid through July. And once that is accomplished, I would sign the order to quash. Sandra, how long will it take to make that payment?
I can look at it today. I have an appointment at 11, but I can get that taken care of and probably get a check wrote out today. And
Your
if
Honor?
need be, I can drop it off on my way home.
All right, yes, Mr. Thornton?
The application that the Schroeder signed for the Sarah application, they did not request, they requested June's rent, did not request July's rent. So at this point, the Schroeders want Mr. Kloppenstein out.
I understand.
And it was always my understanding that once an order of eviction entered, it cannot be nullified by or corrected by the payment of the rent.
I would dispute what Mr. Thornton states due to the fact that the judgment has been satisfied, which is why we made the motion to quash the eviction order due to the fact that the 56-day rule has been suspended.
Well, I have this document called Settlement Statement, Release and Waiver of Rental Arrearage. Dated June 8. But I don't find a signature page. I find a signature page dated June 3rd that they agree that $7,425 by making application to Sarah, the tenant has agreed that if funded, the application only resolves the issue of rent arrearage and fees owed through the date of payment of rental assistance. that other obligations remain enforceable. So they want it both ways. Mr. Thornton, no, if there's a writ and the defendant pays the rent and the landlord accepts it, no one would pay rent if they're going to pay a substantial arrear to get evicted anyway. And now we've got this settlement statement where they agree to accept this money to pay his rent. They are willing to pay his rent through the end of July. The COVID stay ends. My contention when we discussed this earlier, and I explained this to Mr. Kloppenstein, once the COVID stay ends, we discussed the plaintiff just filing a termination of tenancy action for expiration of the lease. And I thought that's what we were going to do. Then they changed course, and I'm not being critical. I certainly wouldn't eat $7,425 of unpaid rent. Keystone is ready and willing to pay June and July's rent. Then the plaintiff should pursue a termination of tenancy action, start fresh and clean, and not accept any further rent. So the question is, do you want June and July's rent or no?
If the court's ruling would be that the order of eviction stays in place, my clients who have not accepted June's rent yet, because it hasn't been paid yet, would not accept it if we can enforce the order of eviction. And the only document I'm aware of that my clients have signed is the owner-landlord application that was signed by them on June 3rd. And under that, the terms of that document, Mr. Kloppenstein or somebody is still required to pay rent.
Yes, and they're ready and willing to pay the rent. I'm going to grant the order. This shows bad faith. They accept $7,500 through May, and they say, oh, by the way, we're going to use this eviction order from a year ago to evict you, even though Keystone is ready and willing to pay the next 2 months of rent. So they'll be made whole through July. Then they can start fresh and terminate his tenancy. Mr. Kloppenstein, have you had any success finding a place to move to?
Yes.
And
By when?
Pardon me?
How soon will you move?
It'll take me, once I commence to move, it'll take me probably a good 4 weeks to get moved out. It took me 4 to 6 weeks to get moved in here. But at the moment, I'm in the process of painting the kitchen and another bedroom. In the other place, I've already painted the living room and another bedroom in the hallways.
Well, that's wonderful. You're taking your time to move out. The Schroeders have been trying to sell this house for 1.5 years. And you're like, well, maybe I can be out in 4 weeks. That's why they're so irritated about this whole matter and want you to be out yesterday.
Your Honor, there's another issue here. I have served, prepared and served a notice to quit on Mr. Kloppenstein that terminated the lease as of July 15th. If the court mandates or forces my clients to accept all of July's rent, that's going to nullify that notice to quit in a case that is not even before the court yet.
All right, I will order that Keystone pay rent through June. Only, not July. Mr. Thorne has started the process, what we had discussed earlier, with an actual termination of tenancy. He's one of our most knowledgeable landlord-tenant attorneys, and I think he and I agree that's the cleanest solution.
Your Honor.
Yes?
There is a dispute on if the notice to quit is in fact valid. However, that is for a case once it begins there due to the contract that was signed with the landlord's application. But that's an issue for another court day.
All right, we'll save that for another date. I will sign your order to quash the original writ.
Thank you, Your Honor.
And they're gonna start over again. Mr. Kloppenstein, the plaintiffs have gone through a lot trying to get you out of there, and in your defense, you probably would have moved a long time ago if you could have found some place to move to. This happened right at the start of the COVID circumstance, and the Schroeders have been trying to sell this house since April of 2020. At some point in the very near future, you're going to have to vacate. I have the motion, Ms. Johnson, but I can't find an order.
I will submit the order to the court today.
All right. Mr. Kloppenstein, you've been served a notice to quit effective July 15th. And it's probably only moving July 15th. That will trigger the next part of the hearing. And the COVID stay will be over July 31st, and a termination of tenancy isn't covered under the COVID stay anyway. So it's fairly imminent. I offered to pay June and July's rent for reasons that Mr. Thornton stated on the record. It's probably not prudent for the defendant to accept July's rent, but they ought to be made whole for June. So Keystone will pay June's rent, not July, and notice to quit has been served for termination of tenancy. You can expect that case to be filed immediately after July 15th. I will sign the order to quash the original order of eviction. This will be much cleaner as a termination of tenancy with the clock ticking in the prescribed manner for a much more legally solid notice to quit. Hopefully we won't get to that point. Mr. Kloppenstein will be able to move into his next place and start over again with the assistance of Keystone. So Rebecca's going to submit to me an order granting her motion to quash the order of eviction. Sandra Cook and Bettina from Keystone are going to remit June's rent to the plaintiff. And then we will have a new case with a new case number and start over as a termination of tenancy. Anything to add, Mr. Thornton?
No, Your Honor.
Ms. Johnson?
No, Your Honor.
All right, we'll start over with a new case number. Mr. and Mrs. Schroeder, I know you're very frustrated, but your lease will get about $8,000, and that's something. Mr. Kloppenstein, good luck in getting relocated. If you get moved soon enough, maybe we won't have to deal with any more of this. All right, I'll await the order and I'll sign it later this morning.
Thank you, Your Honor.
All right, I'm gonna remove everybody. All right, Bettina. That's the last I got for you. I'll see you in a bit.
Okay. Thank you, Your Honor. Have a good vacation.
All right, thanks.
You're welcome.
had a bunch of rent-a-center cases. Are they gone? I have TD Bank